Hello everyone. In this video, we'll talk about what is lease under Transfer of Property Act 1882. When we talk about lease in property law, we are essentially referring to renting of immovable property where the property is given for use but not for ownership. In such an arrangement, the person taking the property does not become the owner at any point of time. And this is the most important idea to remember. So, whenever you hear the word lease, your first thought should be enjoyment of property and not ownership of property. In a lease transaction, ownership of the property never changes and always remains with the landlord, irrespective of how long the tenant stays. Even if the tenant stays for many years, the legal ownership still continues with the lessor. This clearly shows that lease is a limited transfer and not a complete transfer. What is actually transferred in a lease is only the right to enjoy the property. Enjoyment means the right to live in the property, use the property, and benefit from it for the agreed purpose. It does not include the right to sell or right to gift or mortgage the property. This right to enjoy the property is always given for a certain period or for a duration that can be determined. It may be for 11 months, 1 year, 5 years, or even longer depending on the agreement. However, no matter the duration, the tenant never becomes the owner. The person who gives the property on rent is legally called the lessor, whom we commonly call as the landlord. The person who takes the property on a rent is called the lessee, whom we generally call the tenant. This legal relationship between lessor and lessee forms the basis of a lease. This entire concept of lease is clearly defined under the section 105 of the Transfer of Property Act 1882. Remember the section 105. Therefore, whenever you see the renting of immovable property in law, you should immediately connect with the section 105. Let's talk about essential elements of lease. For a lease to be recognized by law, certain essential elements must be present. If any one of these elements is missing, the lease may fail in law. So it is very important to understand these essentials clearly. Firstly, there must be two parties involved in the transaction, namely the lessor and the lessee. One party gives the property and the other party takes it for their use. The same person cannot be both lessor and lessee. Secondly, the subject matter of lease must always be immovable property. Movable items like furniture or vehicles cannot be leased under the Transfer of Property Act. Lease applies only to lands, buildings, and other immovable property. Thirdly, there must be a transfer of the right to enjoy the property. This transfer is limited only to enjoy and not ownership. If ownership is transferred, the transaction becomes sale and not a lease. Another important element is the duration of the lease. The lease must be for a certain period or in a perpetuity, meaning the duration should be identifiable. An uncertain or vague duration creates legal complications. There must also be consideration for the lease, means this may be rent, premium, or sometimes both. Without consideration, the lease is not valid. Finally, the intention of the parties must be to create a lease. If the intention is only to give temporary permission, it may amount to license and not lease. Now look at rent and premium. In a lease, consideration plays an important role, and law recognizes two forms of consideration, namely rent and premium. Both rent and premium are valid modes of payment under this law. Understanding the difference between them is very important. Rent refers to a recurring payment made by the lessee to the lessor. It is usually paid monthly or yearly. Most residential lease arrangements involve payments of rent. Premium, on the other hand, is a lump sum amount paid at the beginning of the lease. It is a one time payment and not a recurring one. In legal language, premium is also known as salame. In many leases, especially residential one, consideration consists only of rent. In certain long-term or commercial leases, consideration may consist mainly of premium. Sometimes both rent and premium are paid together. The law clearly recognizes all these arrangements as valid. What is important is that there must be a lawful consideration for the lease. Now let's talk about kinds of lease or types of lease. Leases can be classified in different kinds depending on their duration and the nature. This classification helps us understand the legal requirement applicable to each type of lease. A lease for a fixed term is one where the duration is clearly mentioned. For example, a lease for 11 months or 5 years is a fixed term lease. Such lease automatically come to an end after the expiry of the term. A lease from year to year is one which continues every year unless terminated according to law. These leases usually require registration. They are common in agriculture and long-term arrangements. A lease exceeding 1 year is a long-term lease. Such leases require compulsory registration under law. Without registration, they are not legally enforceable. A lease in perpetuity is a very long-term lease which may continue indefinitely. It creates a strong right in favor of the lessee, though ownership still remains with the lessor. There are also statutory leases which are created by operation of law. Such leases do not arise purely from agreement of parties. Let's look at a creation of lease. Section 107 of the Transfer of Property Act deals with the mode of creation of lease. It tells us how a lease should be legally made depending on its own duration. A lease from year to year or a lease exceeding 1 year must be made only by a registered instrument. Registration in such cases is compulsory. Without registration, the lease has no legal validity. Short term leases, especially those for less than 1 year, may be created orally. However, even in oral leases, delivery of possession is essential. Without possession, the lease does not come into effect. In a lease requires registration, but it is not registered. It is not recognized in law. Such a document cannot be relied upon to prove a lease. Section 108 deals with the duties of the lessor. The law imposes several duties on the lessor in order to protect the lessee. These duties ensure fairness and balance in lease transactions. The lessor must disclose all material of defects in the property. These defects may affect the use or enjoyment of the property. Concealment of defects make the lessor liable. The lessor must put the lessee in possession of the property. Without possession, the lessee cannot enjoy the property. Therefore, delivery of possession is a fundamental duty. The lessor must ensure peaceful enjoyment of the property. He must not interfere with the lessee's possession without lawful reason. He must also protect the lessees from disturbance by third parties. Let's look at duties and rights of the lessee. This is also includes section under the section 108. The lessee also has certain duties under this law. A lease does not give unlimited freedom to the lessee, meaning lessee has certain restrictions. The primary duty of the lessee is to pay rent or premium as agreed. The lessee has to pay the rent as per the agreement. Failure to pay the rent may result in termination of lease. The lessee must take reasonable care of the property. He should use the property as a prudent person would use his own property. Meaning, the lessee should have some reasonable care and he should use the property considering the properties of his own. The lessee must use the property only for the purpose which it was leased. Using it for unlawful purposes may result in forfeiture. Meaning the lessee should use that for only if he was rented to l- live himself, he should only live. He should not try to sell it or should not make it for another lease to another person. At the same time, the lessee has the right to the peaceful possession. The lessor means the owner should not disturb the tenant during the lease period without lawful cause. Termination of lease. A lease does not continue forever and come to an end in certain situations recognized by the law. These situations are listed under Section 111 of the Act. A lease come to an end on the expiry of the fixed term. Suppose if the contract was made for 11 months, by end of the 11th month, by default the lease comes to an end, that is expiry. Once that is ends, the lease automatically gets terminated. A lease may also terminate on the happening of the specified event. For example, if the lease is dependent on a condition, the lease may terminate by surrender when the lessee voluntarily gives up possession. So if lessee want to vacate the place that he was leased for, so he can surrender the lease agreement, and termination in such situation termination also takes place by forfeiture date to breach of the conditions. In some cases, lease may be terminated by serving a notice to quit. So any of them, leaser or lessee, can serve a notice and can terminate the agreement. Now let's look at lease versus license. What is lease and what is license? The difference between these. Students often confuse here. What is lease with the license? But the two are legally different. Understanding this difference is very important for exams. A lease creates an interest in immovable property in favor of the lessee. This means the lessee gets a legal right enforceable against the world. A license, on the other hand, creates only a personal right. It does not create any interest in the property. Lease generally gives exclusive possession to the lessee. License usually does not give exclusive possession. Lease is governed by the Transfer of Property Act. License is governed by the Indian Easement Act. So these three are the major differences. To conclude the session, lease is one of the most important modes of transfer under the Transfer of Property Act. It primarily deals with renting of immovable property. In a lease, only the right to enjoy the property is transferred. Ownership always remains with the lessor, means with the owner. The law clearly balances the rights and duties of both lessor and lessee, means both owner and the tenant. A proper understanding of lease helps in avoiding disputes and litigation. If you found this video helpful, please subscribe to the channel. Thank you for watching.